Hi, I'm Paul Vojchehoske. I'm your real estate instructor, and my mission in life is to keep you out of real estate jail. And quite frankly, one of the easiest ways to get thrown into real estate jail is screwing up the lead-based paint disclosure. Today we're going to be talking about the lessor, lessee, or the landlord-tenant lead-based paint disclosure. A couple of things before we actually get into showing you how to fill this out and some things you need to understand with this. I want to preface this entire video by saying, number one, this is not legal advice. It's for informational purposes only. If you have any kind of legal question, I have to recommend that you talk to your attorney. Number two is, understand I teach this from a strict risk management perspective. In the landlord and property management communities, risk management and the practice of good risk management just as important as the bottom line budgets and everything else that you do in this industry. Number three is understand that I teach this from a federal perspective. This is a federal program. However, many states have created their own lead enforcement program. A lot of states like California, Illinois, Michigan, quite frankly, Maryland's probably the king of the lead enforcement community. They're more restrictive than just about every other state. So you have to make sure that you comply with both. And then the last thing I would like to just point out, because this is very important for you, for your processes at the local level, the lead-based paint disclosure, whether it's the buyer-seller one or the lessee-lessor, it is addendum number 1 to the lease agreement or addendum number 1 to the purchase agreement as per federal code. That means you are required to provide the lead-based paint disclosure to your tenant for them to review, initial, and execute prior to them signing any lease agreement. Failure to comply could be an $11,000 civil penalty. So you want to make sure in your processes that it's set up where this disclosure is given to your prospective tenant and ultimately your tenant prior to them signing the lease agreement. All right, let's get into the actual disclosure itself. We are going to be discussing this form, the lead-based paint disclosure. We're going to be talking briefly about the protect your family from lead in your home. And then thirdly, again, I teach this from a risk management perspective, so what you need to include in your lease agreement. All right, so let's go to the lead-based paint disclosure. Three things to understand here. Number one is this document is cut and pasted directly from the Code of Federal Regulation, which we refer to in the community as the CFR. Every letter, every word, even the italicized font comes from the Code of Federal Regulation. The EPA has cut and pasted this and put it on this disclosure for you to fill out. Number two, you may not write on this form at all other than the property address at the top. I see a lot of property management companies where they have, because they have so many forms, they have like a menu of forms or a catalog of forms, and they like to include this in there, and they'll actually put the form number down here. You know, like Aspen Ridge Apartments form number 1, or Cheatham and Howe Property Management Company number 1, or whatever. The point is nothing can be on here but the address and the fill in the blank answers. The auditor has the latitude to nail you with a notice of violation and ultimately a civil penalty, and they do it. I have seen several of them. Okay, so remember, address only on this. And the last thing to understand with this is there's two disclosures separate and distinct of one another included on the same form. So we have the lead warning statement and then the disclosure about known lead hazards. Okay, the EPA was kind enough to put it on the same form. However, we are independently required to present these to our tenants. I'll give you an example. Let's say that you get audited and you can't find this disclosure. The auditor can, and I have seen them, issue notice of violations. One notice of violation for failure to prove that you provided the lead warning statement to your tenants, and number 2 is failure to provide the actual lead hazard disclosure. They're two separate, distinct disclosures that have to be made. Now, here's what I've done to kind of, from a risk management perspective. So I included on my lease, right here, this is the very first page of my personal lease. If the property was built prior to 1978, then the tenant is going to acknowledge by signing the lease agreement a couple of things. Number one, they acknowledge that the premises was in fact built prior to 1978. Number two, that they have received the lead-based paint hazard disclosure which is the form we were just looking at. And number 3, they are acknowledging that they did receive the EPA's Protect Your Family from Lead in Their Home pamphlet, which is required by law for us to give it to our tenants. And then this is kind of important too. It's they're acknowledging that they have read the lead warning statement below. Then I've actually included the lead warning statement here on page 1 of my lease. This way here, if I were to actually lose the lead-based paint disclosure, at least I'm minimizing my risk by showing that the auditor, or showing the auditor that I actually complied with the law and they did receive the lead warning statement. That's the only reason I have it in there. All right, so let's get back to the lead-based paint disclosure. The lead-based paint disclosure has the lead warning statement, and then it has the disclosure of lead hazards. The lessor disclosure is first. We're actually going to read each one of these line by line so you understand what the obligation is. If you're just a landlord and you're not under property management whatsoever, it is your responsibility to complete A and B under the lessor's disclosure and then sign it as the lessor and date it. And you want to date it the day that you signed it. So let's take a look at A. It says presence of lead-based paint and or lead-based paint hazards. Notice it says to check I or 2I below. This is very important for one simple reason. I have seen notice of violations, and I have seen numerous notice of violations from auditors that have nailed landlords and property managers for putting an X here, for putting initials here. They read the code in its strictest form. And they have a lot of latitude to do it, just like an IRS auditor has a lot of latitude when they're auditing your tax files. The interesting thing is, and what's kind of disturbing actually, is if you were to call your regional director at your regional EPA director, they deny it. They'll say, you know what, we would never do something like that. In fact, I'm not even aware of such a notice of violations. However, I can tell you that it does go on. I've seen it personally by clients of mine. So the point is we want to make sure on this form that we read the directions and the instructions specifically and comply specifically with what they're asking. So if they want to check, we're going to put a check here. All right, so let's look at A. Presence of lead-based paint and or lead-based paint hazards. It's required that we check 1 or 2 below. Let's look at small I. It says known lead-based paint and or lead-based paint hazards are present in the housing. Explain. Now I want to point out here that known lead-based paint hazards can only happen as a result of a lead assessment. The fact that the property was built prior to 1978 in and of itself does not meet the threshold for disclosing known hazards. Actual knowledge is required, and what's actual knowledge? That means we have an assessment. Or the other option is lessor has no knowledge of lead-based paint hazards in the housing, so we're going to check one or the other. Let's look at B. B says records and reports available to the lessor. Again, it says to check I or 2I below. And it says lessor has provided the lessee, which is the landlord, has provided the tenant with all available records and reports pertaining to lead-based paint and or lead-based paint hazards in the housing. List the documents below. So we would list the documents. So maybe we had a lead assessment that was done. So we would write that in there. Lead assessment was done on this date. And then we have to provide copies of that report. The other thing to remember here, it says lessor has provided the lessee with all available records and reports pertaining to lead-based paint. So what this means is any report that you have, you must provide, even if it's a positive report. So I'll give you an example. Let's say that we have our home tested for lead and the assessment comes back that they found no lead anywhere in the house. Then it's still a report and a record pertaining to lead-based paint, so we would therefore have to provide this to our tenants. A lot of people get confused and they think, well, only disclosure is required if the report shows that there was lead, and that's just simply not the case. 2I is lessor has no records or reports pertaining to lead-based paint. All right, that's how we fill this out. And again, we have to check one small I or 2I. I have seen this scenario and I wanted to address it. Let's say you get a lead assessment done, or maybe the previous owner did and they passed it on to you at closing when you bought the property, but you have since lost it. You cannot find it anywhere. Well, you do have actual knowledge of lead-based paint hazards in the home, so you would have to make sure that you check small I and say, yes, approximately this date, the home was tested and they found lead hazards in these particular areas of the home. And then down here you would check I have no reports, or the lessor has no reports. You got to be honest with this disclosure here. All right, so if you're a landlord, you're going to complete this section. Now let's talk about a more technical aspect of the code. Is what happens if you're a landlord or an owner and the property is under management. Now I want to point this out very specifically for you property managers. It's very important in your management contract that you have a provision in your management contract that says that you as the designated broker and your authorized representatives have the authority to sign and execute any and all disclosures, whether they're state mandated disclosures or federal disclosures like this lead-based paint disclosure. That's very important, because technically what happens if you don't have that provision in your management contract, then the owner must fill out the lessor's disclosure section each and every time a new dwelling comes up for rent. So if you have an apartment community of 300 apartments, that means every time a new unit comes up, a new disclosure has to be generated for that apartment unit, which you cannot have as a master copy of this form the owner fills out and then you just keep it in the file, and every time one comes up then you make a copy of the master file. I know I have witnessed several notice of violations from auditors for that practice. So you want to make sure that if you don't have that in your management contract, that the owner must complete this section each and every time a new dwelling comes for rent. Then you as the property manager would then initial here and then sign at the bottom as the agent. So in this case, the owner would sign as the lessor and date, and then you as the property manager would sign under agent and then date it. Now let's look right here, the property manager's acknowledgement or agent acknowledgement. Notice it says initial. So up here we had checks. Now we're down here on the agent's acknowledgement where they have to initial. So you as the property manager, you're going to have to initial here. And basically what E says is the agent has informed the owner of the owner's obligation under 42 United States Code section 4852D, and they are aware of their responsibilities to ensure compliance. Now what that means is you as the property manager, you're initialing and acknowledging that you had the discussion with the owner that they're responsible to, number one, complete this section, and number two, provide any reports or any known lead hazards. That is their obligation. Your obligation is to inform them that they must disclose. That's basically what it is. All right, so let's say you do have that provision in your management contract that says you as a designated broker and your authorized representatives have the authority to sign any and all disclosures, state or federal, it doesn't matter. So once you have authorization, that means from there forward, you as the property manager or your authorized representative, you're the ones that have to fill this section out on behalf of your owner. All right, and then the last thing is I want to talk about the lessee's acknowledgement here. Now notice once again we're initialing. Now the lessee is the tenant and they are initialing. C and D, they're responsible. Now I want to talk about C because C is very controversial from the regulatory perspective. So the tenant is acknowledging when they initial that they have received copies of all the information listed above. So if there are any reports here or there's any known lead hazards, they're basically initialing saying we acknowledge the above disclosure. The question I get all the time is what happens if there are no known lead hazards and there are no reports? Should I still have the tenant initial? And I can't answer that. I have spoken to 2 directors of enforcement in 2 different EPA regions and I got a split verdict. I have spoken to several auditors over the years and it's a split verdict. Some say that it still must be initialed because quite frankly they are acknowledging that they received the information above on this disclosure even if there is no reports and there are no known hazards. The other half said no, just put NA for non-applicable. I can't answer that. If I was advising you, here's what I would tell you to do. I would try to get a hold of whatever EPA region you're in. I would try to get a hold of the director of enforcement for that region and email them if you can. Otherwise a phone call, but an email is better, asking them their position on it. And then if you can get an email, I would just put it in the file. Okay, at least then you have some documentation. D, it says the lessee has received the pamphlet, Protect Your Family from Lead in Your Home. That is this pamphlet right here. If you're not familiar with it, you should be. You can get this pamphlet right from the EPA website at epa.gov/lead. Now, if you go to epa.gov/lead, you're going to find that this pamphlet is in color, it's in black and white, it's in several different languages, Spanish, Vietnamese, so on and so forth. The key here, though, is to remember right here this date. You're required to provide your tenant with the most accurate, current, and up-to-date pamphlet. Failure to provide that pamphlet puts you at substantial risk for a notice of violation. So we have to have our tenants initial here that they received this pamphlet. Now, one thing I'd like to point out here, it says the lessee has received the pamphlet. So they're initialing here, making the acknowledgement. I have seen notice of violations for failure to get all the tenants' initials here. So you have to be careful and know that if your lease agreement has 2 tenants, so Tim and Sally Smith sign the lease agreement, then Tim and Sally Smith must sign this disclosure, and Tim and Sally Smith must initial up here. The most common mistake that I see as a consultant is I'll see that Tim and Sally Smith sign the lease agreement, Tim and Sally Smith sign this disclosure, but only Tim initialed C or D. The auditor does have the latitude, and many do, write you a notice of violation for failure to get that second initial. So make sure from a risk management point of view that you have a process in place, a checks and a balance that always ensures that you get all the documentation and the initials and signatures that you need. Last but not least, and then we're going to be done here, it is very important that everybody that needs to sign this does sign it. It's the certification of accuracy. This is where everybody signs. We want to make sure that if applicable, the owner signs here and puts the date. Obviously the tenants sign and put their date, and then the property manager or the property manager's authorized representative signs as the agent and dates. And then keep this in mind, it's very, very rare. Occasionally the tenant will have an agent represent them on the tenant side. In this case, then they would have to also sign and date it. So this is pretty much the lead-based paint disclosure. My advice to you is if there's one form that you pay detailed attention to make sure that it is filled out correctly, it's this one. Remember, you're subject to a notice of violation of a civil penalty of up to $11,000 for every little infraction. So from a risk management point of view, we want to make sure that every T is crossed, every I is dotted. Okay, that's all I have here. Till next video, my name is Paul Vojchehoske. I appreciate you hanging with me. Hey, if you have a question, make sure that you ask it below and I'll respond. If I don't know the answer, I'll make sure I get it and respond. If you have a comment, a story, I would love to hear about it. Please post it below. Till next time, happy landlording.